Testimony is underway in the racially charged murder trial of a former Texas high school athlete. The case getting national attention amid competing claims that the defendant acted in self-defense. Let's bring in criminal defense attorney and federal litigator Vikas Bajaj. I mean, the case is getting a lot of national attention with good reason here, Vic. I mean, this really has kind of stoked a lot of emotions around the country. Josh Ritter says this case is all about kind of reason and ration. He said the following, watch.
It's all about reasonableness. Did he perceive any kind of threat from that other young man as reasonable? Was his response to that threat reasonable? Was the use of deadly force, the stabbing, reasonable? The prosecutor's contention is that no, it was not. This was maybe a physical altercation, but it involved pushing and shoving, and he brought it to the level of using a knife to stab this young man to death, who died in the arms of his twin brother.
Yeah, is it a fair point, Vic?
It's a very fair point, and he just hit the nail on the head, putting it in very clear terms. The federal actions are different than state actions. This is a state case, so we depend on the law in the state of Texas. The law in the state of Texas says you don't bring a gun to a knife fight, and you surely don't bring a knife to a fist fight. So the actions, as Josh has just outlined, need to be reasonable in response to what one may perceive as a deadly threat. The facts of this case are not about race. The effort is to make it about race, but when you actually look at the judge's ruling saying that race is not a factor in this case, avoided and overruled the defense's objections for a few African-American potential jurors that were excused. The judge says, time out. This is not about race. Let's look at the law. Yeah. The law says he may have acted unreasonably, and this is a tough case for that jury to decide.
I want to stay on that topic if I can, because we had Austin Metcalf's dad. He was on the channel about a little over a year ago, and he was saying exactly what you said, Vic, that this is not about race. Listen to him.
This was not a race thing, and this is not a political thing. This is a human being thing. This person made a bad choice, and it affected both his family and my family forever. It's a very unfortunate thing.
But as you say, some jurors, potential jurors, were dismissed because they made it about race. You see these protesters outside making it about race. Hard to keep it out of a case like this. Is it hard when you're trying a case like this to keep race out of the equation?
It really isn't hard, because a lot of that stuff that's at the footsteps of the courthouse never make their way into the jurors' ears. They hear it, they see it when they're walking in, but the judge specifically says you will only entertain evidence that I allow you to listen to or to see in this case. If you look at the evidence in this case, this is not about race at all. It wasn't a white versus black, or, hey, this is a racial issue with you not letting me in your team's tent, which is what this all started at. It's an overreaction. Now, let's also be clear. The state has a difficult task here, because when you look at self-defense, you have to go through a microcosmic dissection of millisecond by millisecond. What was in the accused's mind? Right. Did he feel at that point in time, if it may not have been at the first point in time, that he had to defend himself? Self-defense is malleable. It's not a given yes or no. Also, the victim in the case was 6'1", weighed more, an athlete like Mr. Anthony was. But all things considered, if the jury sticks to the law, the defense has an uphill battle.
I've got a few seconds left here. State of Minnesota declining to bring charges for the anti-ICE protesters that stormed into that church. Here's some of the video. You can put this video on the screen, Vic. Talk while the video's going. Is this the right decision?
Right, absolutely. And what you can see in this video here is that there's a lack of certain evidence that the state was looking forward to. Now, let's keep in mind for our viewers and listeners here, Trace, that the state looks at crimes against the community, vandalism, threats, battery, and things of that nature. What we do not see in this video is property damage, threats to individuals' liberty, and that's why the federal government is involved, because the federal government has a bit of more ammunition. The FACE Act, which is a Fair Access to Clinics Act, which also applies to places of worship. This is a national concentration, not a state concentration. You'd be hard-pressed to find a state, local official in Minnesota saying, we're going to go ahead and file charges. And that's why we have dual sovereignty, and the federal administration is having their eyes on it.
Good stuff. Vikas Bajaj, thank you much. Very much appreciate it.